Hello, everybody. This is Aaron Gelb, and we will get started now with our webinar on employee handbooks, training, and internal audits. It's nice to talk about something that is not pandemic related, and I don't think we even plan to talk about any pandemic related policies. We'll be offering plenty of other webinars for those of you that are interested in those topics. I think it's important, obviously, as much time and attention is understandably and necessarily been focused on COVID and all the measures and policies and new procedures that go with it, to talk about kind of the infrastructure that goes around or enables you to respond to things like this, and that because we will one day presumably come out of this and return to whatever is normal or will be normal. We still are going to need handbooks. You're still going to need to present training. You're still going to want to be doing internal audits. So we want to basically give you the framework, talk about some of the thoughts and considerations that go into these various essential elements of running, managing a workforce. So we're going to do brief introductions. Then I'll go over the agenda and we'll get right into the handbook. So again, my name is Aaron Gelb. I'm a partner in the firm's Chicago office, where I focus my practice on occupational safety and health matters involving inspections and citations and audits, internal safety and health audits, as well as client counseling and advice. I also have devoted much of my 25+ year career to representing employers, exclusively employers, in EEO matters, handled an extensive number, hundreds, if not at this point in my career, thousands of EEOC charges. I've litigated employment cases, tried a number of cases to juries across the country in various jurisdictions. Handled employment arbitrations, bench trials in front of agencies, all that fun stuff. But one of the parts that I really enjoy is the proactive piece. It makes my job a lot easier when my clients have really good procedures, really effective training, and have demonstrated a proactive effort to instill that in their culture. And so we'll talk about those things in a minute. I'll let my colleague Bita introduce herself and then we'll get started.
Hi all, thanks so much for joining us today, and thank you, Aaron. My name is Beatvilash Kerry, and I am an associate at Kerry out of the Washington, D.C. office. Before joining the firm, I was an attorney investigator for the U.S. Chemical Safety Board. And as an associate, I provide advice and guidance on responding to workplace safety complaints and contesting OSHA citations. I also represent clients in a broad range of employment issues and counsel employers on workplace policies and procedures, including full employee handbook reviews. So looking forward to getting into handbook development and reviews. And with that, I will pass it back to Aaron to go over our agenda for today.
Thanks, Bita. So as far as the agenda goes, like I said, and it pretty much tracks the title on the front page of the slide deck. We're going to begin by going through employee handbooks. That really is kind of the backbone of your overall compliance efforts when it comes to labor and employment and related issues. We're going to talk about drafting and advising and revising your handbooks. Presumably everybody has a handbook. There may be some folks that are listening that don't. Maybe you're a new company. Maybe you've gone through some significant changes, so you're going to start from fresh. We're going to talk about what the really must-have elements of the handbook are, from certain procedures, certain policies, etc., and then kind of how to go about reviewing those specific policies and procedures. I wrote an article a number of years ago that I think garnered a decent amount of attention, and one of the things that I argued or addressed was when you're trying cases, and this is sort of things I think that you learn or have an opportunity to see in action when you're trying cases in front of a jury and you're getting feedback from the people who would be deciding these cases, is having a really good handbook is an assumption that outside parties, whether it's a judge, whether it's a jury, whether it's an EEOC investigator, I don't think anyone would expect that any employer that has been in business for any period of time would not have a good handbook. If you don't, if it's kind of slapped together without much thought, without much preparation, it's not really customized to your business, I think you're already starting at a deficit. The other things that then, and that's been as long as I've been in practice, that's really been the case. And then during the course of my career, I think back to well, then there was training. The training wasn't always a thing. I mean, there's always been training, but it wasn't kind of as ubiquitous as expected as it is now. And I kind of talk about the third phase, if you will, is then living those values. If you put them in a procedure, if you train on them, then you need to live them, meaning you need to fulfill, carry out, comply with those policies and expectations. And that's kind of what you get at or trying to verify through those compliance audits. As far as the training piece, we're going to talk about some ideas, some thoughts that we have with respect to training in the digital age. Obviously, training today is very different than the sort of training that my clients did when I was a new associate back in the mid 90s, and some of the best practices that we see there, and then kind of just trying to share some thoughts about how training should support your overall compliance efforts. So with that, let's jump into the employee handbook section or portion of our presentation. As I said, one of the main thrusts or main considerations that I always try to emphasize is the handbook really should, as I said a minute ago, should be customized. It should be specific to your workforce, to your operations. If at all possible, I always discourage against kind of the just finding something online, downloading it, replacing any references to the prior, or taking someone else's handbook and using it for yourself. It may help in some regards, but I think it's certainly going to be apparent at some point sooner rather than later that not much thought or effort was put into it if that's the approach you take. But what are the reasons? Why do you have a handbook, right? As kind of one of its most basic levels is it's there to obviously to welcome employees to your organization. It sets the tone, how it's written, what the policies are in the handbook, what you choose to emphasize. It's your opportunity to set expectations. For some of my smaller clients, it can be a relatively short document. There are only a handful of essential key policies, the sorts of things that might be required by law or regulation, or that something is essential to that company, one of their priorities, whether it's performance, whether it's safety, et cetera. Everybody doesn't need a 120-page handbook, in my view. And in some organizations, that it could be kind of counterproductive to have something that is so detailed, maybe contains so many superfluous or unnecessary policies that people just kind of get it and set it aside and don't really read it. It's also a good resource. It can serve as a good resource for your employees, for your managers, to look for and obtain answers to questions that come up frequently. It can save time and effort so managers aren't being bombarded with certain questions. Employees are encouraged to consult the handbook, use it. It's a living document. Presumably, perhaps if it's available on your company's intranet or in some other electronic format, recognizing that people may not always have access to the paper document. And of course, having just submitted a EEOC position statement earlier today, one of the things that we were working on was making sure that we had a copy of the acknowledgement form signed by the charging party. in which they had attested to receiving, understanding, and having an opportunity to ask questions about the handbook. That's something we I always try to include in every position statement, for the very reason on the first bullet point. We held this individual accountable to the policies in the handbook where they fell short. We want to be able to show that they were made aware of those handbook or of the policies or procedures in that handbook. So another question or something that comes up sometimes from clients that are asking, like, do we, how many handbooks do we need? Some clients have a manager handbook and an associate handbook. Others have a handbook, one universal handbook. I like to see, or I think it can be effective, depending on the scope and of your enterprise or your organization and the types of obligations or expectations your managers have, to create what are called procedure manuals that serve as kind of a supplement or alternative to the handbook itself. Typically, an employee handbook obviously is intended for your employees. I like to see handbooks that are written in understandable manner, approachable, plain language, simple formatting. Graphics are fine and nice, but not essential. You obviously need to be careful when drafting and using handbooks, that you leave yourself some flexibility, some wiggle room, if you will. So the handbook, and a lot of this can be accomplished also through the disclaimers we'll talk about in a minute, but where the handbook doesn't become kind of a sword or a tool that an employee can use to then prove that they were not treated either fairly or legally. Procedures manuals, on the other hand, are going to be used primarily, if not exclusively, for your management level, your supervisory employees. It provides a more detailed explanation of practices and procedures, what's expected of the managers. It might include documents or forms. One example that I found to be particularly effective, I had a large retail client that was having some pretty significant challenges with ADA compliance, kind of as it meshed with the FMLA, and they were being investigated by the EEOC. We kept finding some of the challenges that they were encountering in terms of the interactive process and managing that process with employees who had requested reasonable accommodations for their disability. So we set out and created a procedure manual specifically for the interactive process. Its distribution was limited to the HR department. It had basically a step-by-step process. Given the size and scope of this organization and its geographic reach, we felt it was necessary to include rough approximate timelines. You will receive a response to your request within this time period. The human resources professional who's tasked with that then has forms to use, kind of flow charts to follow. And the point being, in that case, given the number of HR professionals in this organization, the fact that any one of them at one point in time may be tasked with responding to an accommodation request, we didn't want to leave it to chance that perhaps there's one or two subject matter experts who normally handle them, but what happens if they're out, they're on leave, they're on vacation, they're sick, so it lands in somebody else's lap. They're not the subject matter expert. That's likely increasing, perhaps significantly, the likelihood of that a ball gets dropped, that something is overlooked. Maybe they didn't respond in the appropriate time period. They didn't use the correct forms. So having a procedure manual for that can really go a long way to avoiding those sorts of hiccups. Increasing the likelihood of compliance, of putting together, of getting to the right result with the accommodation request, and then having documentation and the ability to show, if challenged in an agency or in a court of law, that you did what you're supposed to be doing. So that there is no, I don't have a list of procedures or policies that should have manuals for them. Again, I think it's largely going to be something that you decide on an organizational basis, like I'm describing with this one client, where we felt that the reasonable accommodation or interactive process was something that definitely needed a procedures manual. So thanks, Pita. So as far as, what are some other considerations before you actually sit down and start developing, either creating or updating your employee handbook? As I said before, take stock of your organization, of your operations. Where obviously, what states or cities do you have locations? Do you need a California specific handbook? Or would you prefer to have a universal handbook that has addenda at the back? I've seen it done both ways. I don't know that one is better than the other. I think it really, again, depends on what approach you would prefer. I think there could be, probably a consideration that if you have employees in one state, seeing that employees in another state are getting, benefits that are different or preferable to them, that might start asking questions of, why are they treated differently than us? But it's not necessarily, I don't think there's necessarily a better approach to having a universal handbook or one with various an addendum for certain states. Think about the policies that you have in place, how long they've been how long they've been there, how they've changed, how they've adapted or morphed, and kind of think about whether you need entirely new ones, whether you're supplementing them. What are the issues that perhaps, whether it's surveying management, surveying employees, are there things that we need procedures for? Are there procedures that are particularly problematic or not working for us? That's all part of kind of the gap analysis that I think you want to do. Maybe you learn that attendance is a bigger issue than you thought, so we need to revisit our attendance policy. Maybe there are dress code issues. Maybe there are nepotism issues. So maybe we need an employment of relatives provision, things like that. And then, of course, perhaps the most significant part, the part that Bita works on so expertly so often, which is really a lot of heavy lifting, but I think well worth the work and the time spent, is doing a legal review of the various policies, laws, whether it's obviously federal laws, state, city, county, wherever you're operating. We certainly have seen that in the past year and a half, that the number of jurisdictions or government entities that might impose requirements, whether it's having a policy, having a certain type of training. So you really want to make sure, obviously, as before you set out to draft it, that you're aware of what's legally required and needs to be addressed in a certain manner or in a certain way. And then a number of additional considerations. Sir, I always encourage clients to think about the languages that are prevalent in your workforce, and identify a means or mechanism to have the handbook translated as necessary into those languages. It's not the sort of thing that I would think you'd want to wait until after the handbook is published, and then you realize, oh, we need to have this translated, and now you've got this situation where the English-speaking employees have a new handbook, and it could be weeks or a month or more before employees who speak other languages have a copy of the handbook. It doesn't look good. It's not good for employee relations. I think it's also a good idea. I just went through this with another client during the course of an investigation where changes have been made to some policies and procedures, and they had a really good practice of, at the bottom of the new revision, little key that summarized the changes. So it was readily understandable or recognizable what had been changed, whether it's adding highlights or different colors to the changed portion, or even just if it's circulated electronically by email, a transmittal or cover email that highlights or addresses those changes, to really, particularly if it's something that you want to emphasize, that's a nice way to be able to do that. You could also even consider doing FAQs. I think we've all become expert in FAQs over the past year and a half, and really I think have become to rely on them when new laws or regulations are promulgated. Having those FAQs that help people understand what the policies or the laws require can be helpful. So I think it's a good practice to consider using when you're either launching a new handbook or making significant revisions to it. Again, I mentioned this earlier about the value of having an acknowledgement or verification of receipt of the handbook. Just make sure that you have some verification for that process itself. I've seen too many situations where in the course of preparing for an investigation or a response to a complaint or a charge, oh yeah, we've got a handbook receipt for everybody except the charging party. It just always seems to be the way that works out. So that's one of the things that you can also address through audits, as we'll talk about a little bit later. And then think in advance of what sort of process you want to have in place for periodically reviewing and updating your handbooks, whether it's on just kind of every 2 years, every 3 years, we're going to do that. Obviously, there are going to be new laws that are introduced from time to time that will kind of throw that out the window, but just make sure you build that into the process, kind of as part of in essence, a focus on continuous improvement. So I think with that, I'm going to turn it over to Bita.
Great, thanks so much, Aaron. Okay, so let's get into drafting. So as Aaron already mentioned, you'll want to start with a welcome message and or your mission statement. And we'll get into each of these points in more depth in a couple of slides, but just providing here sort of a high level overview in terms of how to organize the handbook for now. And again, this is very broad, sort of minimal requirements. You can certainly include more, but just kind of wanted to go through from an organizational standpoint, what your handbooks could or what we might recommend should look like. So after the welcome message and mission statement, typically comes your equal employment opportunity statement. You'll also want to make sure you put up front your at-will statement as well as contractual disclaimer. That's really important to put up front so that there's no confusion about the nature of your employee's employment. You'll also, of course, want to include your policies against harassment and retaliation. And next come your personnel policies, things like how employees will be compensated, your policies around various types of leave, how employees' performance will be evaluated, and things like that. You'll also want to include a description of employee benefits, health insurance, retirement, and so on. Again, we'll get into sort of more detail about each of these points in a couple of slides, but just providing here sort of what the organization should look like. And again, there's definitely more room for any additional information you'd like to include. But as Aaron mentioned at the very end, we do recommend having that acknowledgement of receipt that the employee signs once they are hired. And again, like Aaron mentioned, making sure you have a process, right, to ensure that you have copies of all those signatures. And we call it an acknowledgement of receipt, but it really is more than receipt. Aaron also mentioned this. It really should detail how the employee has read and understands the handbook, that the employee has had an opportunity to ask questions about the handbook. So it is more than just handing it out. It's allowing the employees the opportunity to really understand it, to ask questions about it, to sort of that they fully embrace it. And again, the acknowledgement of receipt is particularly helpful in case you do need to make any legal defenses against a charge or complaint. Hopefully not the case, but always better to be prepared in advance. So next, again, before going into a lot of substance, we just wanted to point out some suggestions about the tone of the handbook. Again, the handbook is directed towards employees, so we recommend using a positive and professional tone that matches your company's culture. We also recommend using plain language to explain the policies and procedures so that it's user-friendly. Employees should want to refer to the handbook if they have questions and feel like it's really a resource for them. That sort of cuts a lot of time into having them come to supervisors or management, right, to ask those questions. If they feel like they can go to the handbook, that's where they'll go, and hopefully their questions will be answered just by referring again to or refreshing on the handbook policies. The next point is really important. It's avoiding promises. I think a lot of employers tend to actually overcommit. You want to set expectations, of course, but not provide that sword in the event of a dispute. So saying things like "we will" or "we shall," that mandatory type language. And I apologize if you hear a helicopter in the background. I'm in downtown DC and it's just noisy all the time. But anyway, saying things like "we will" or "we shall," making those mandatory, those commitments, promises. It's okay, but the most important thing is that you actually follow those things. So other than anything required by law, of course, you can, and we think you should generally use more permissive language. Things like "we may," or "we typically will," or "we'll consider," so that in case there are gaps with respect to enforcement, which happens, right? You sort of set out to follow everything, to the letter, but sometimes there happen to be holes, even with employers, even if you have all intentions to carry it out full force, things can just happen and slip, and that's just the unfortunate case. So we do feel like using this language is really helpful in the event of a dispute or if a charges or a complaint is filed. And the last point, you want to maintain an appropriate level of detail to avoid the creation of an explicit or implicit contract. And we'll get into that a little bit more in the next slide. So a few points on at-will employment. And what that means really is that either side can terminate or leave with or without cause, with or without notice. At-will employment is a presumption, but you'll want to be careful because it may be rebutted. There is case law that states that a personnel manual that includes specific preconditions that must be met before employment will be terminated. If those preconditions are sufficiently clear, then they can rebut the presumption of at-will employment. So on the other side, there's law that a personnel manual that makes general references to permanent employees and discusses reasons management can terminate employees. That's too ambiguous to rebut the presumption. So one thing you want to make sure you do in your handbooks is to state upfront that employment is at will, but not just do it upfront. Also make sure to repeat it sort of throughout your handbook, and especially in places where there might be cause for confusion. And that's the example we give is if you use an introductory, also called a probationary period. Generally, we don't recommend introductory periods as employees often misunderstand being, quote, at will as applying only during the introductory period. That's often not the case, usually not the case. So we tend to advise against those introductory periods. But if you do include one, again, just make sure to be very clear that it does not change the at-will nature of your employee's employment. All right, moving on to the welcome statement. Again, you'll want to include a description of your business, your mission statement, your culture. This is an opportunity for you to introduce yourselves to your employees. But at the same time, one thing I often find in reviewing employee handbooks is that they're signed by the employer. And that's something we definitely advise against. If you do sign the handbook, it can create a statute of frauds issue. And just to give a little bit of background, the statute of frauds is common law concept that basically requires written contracts for certain agreements to be binding. So you don't want to be signing anything that could be later found to be binding against you. So we don't recommend having those signatures. I'll often, as I'm reviewing handbooks, I'll often make a comment bubble. We do not advise signing this handbook here. Another thing is, often we'll see presidents or CEOs sort of including their names, right, as the signature, as the party who's signing. We typically, again, don't recommend that, for that statute of fraud issue, to the extent that it's signed, but also because presidents and CEOs often change. So that's not something, obviously you'll be reviewing your handbooks frequently and periodically. That is advice we give, but certainly we don't want to have to prompt you to do it, anytime that the president or CEO changes. It should typically be more for regular review or anytime you have sort of substantive changes to your policies and procedures that would sort of trigger you to thinking of taking a second look at your policies in the handbook. And we've discussed much of this, but next point on there is the opening disclaimer. You want to disclaim that nothing in the handbook creates a contract of employment. You'll also want to state up front that you have the right to modify or delete policies in the handbook without notice. So that gives you that flexibility, right? That if obviously you can't change the law, but if there are permissive policies that you have in there that are up to your discretion, voluntary, and you want to change them, then you'll want to make sure that employees are on notice that you can do that, and it can be without notice that you can do that at the time that you please. And again, the last point, we'll keep hammering this, is that you'll want to make sure you disclaim that the employment relationship is at will. Again, because we just don't want to create any kind of confusion around that. Going on to your EEO policy. So why do you want an EEO policy? For starters, it's the law, right? Even if you practice it, right, you'll want to make sure you take credit for it in writing it in your handbooks. And letting your employees, of course, know that you take discrimination seriously. So it's good to have it up front. It is serious, so you'll want to include it there. So it's for that, demonstrating compliance part, but also hopefully it's not the case, but in case a claim or a charge is filed, it definitely will help support a legal defense against any kind of discrimination claims that you do have this EEO policy against discrimination, and that employees are aware of it because they've signed the handbook. Next, you'll also want to outline a complaint procedure for employees who feel they have been subject to discrimination. So that's really important. It allows employees a method, right, by which they can rely and that they can refer to in case they do feel like they've been discriminated. What can they do about it? Even further than outlining one procedure, we really advise offering multiple avenues of making a complaint internally. And the reason for that being is that, say, for example, the employee feels that they've been discriminated by their supervisor, and the method for making a complaint for that discrimination is notifying your supervisor. Well, the employee is going to feel a little bit uncomfortable, right? Going to his or her supervisor about discrimination made by that same person. So we do always advise offering multiple avenues of complaint. So one thing, it could be really simple. Notify your supervisor and or HR, or just providing different avenues for which the employee can make a complaint internally, I think is really beneficial. Otherwise, I think employees do sort of feel more encouraged if they only have one avenue and they feel like they can't use it, that internal avenue, then we do find that employees will go externally. And what that means is filing that formal, official, legal complaint with whatever commission, whatever board they decide to go to for making that complaint. So I think it is in our employers' interests to keep these complaints internal, to resolve them internally if we can, before sort of taking that higher level step of having an employee file a formal or official legal complaint. And then again, you'll want to include your policies against harassment and retaliation, of course, in the EEO section. And touching just briefly on accommodations, I think the greatest thing I find is that, or the most common thing I find is that we'll see ADA accommodation policies touching on disabilities, but we often find that they don't, accommodations don't touch on religious accommodations. So that the religious aspect of it. And of course, we do advise having both. So covering disabilities, but also covering religious reason and sincerely held religious beliefs.
And just to jump in real quick, I kind of promised myself I wouldn't use the word COVID today, but with vaccine mandates and the potential for or the anticipated Fed OSHA COVID vaccine ETS, I know a number of my clients are experiencing the initial parts of what I think is going to be a tidal wave of religious accommodation requests. So that would be, I think, priority one for a lot of folks to look at your accommodation policy, see if it has, see if it covers religious accommodations as well, and then maybe kind of consistent with what I talked about earlier, consider putting together a religious accommodation procedure sheet or guidelines for your HR team. Thanks, Vita.
Yeah, absolutely, Erin. I think I've been trying to do the same thing, right? Trying not to talk about COVID-19, but I think it just kind of infiltrates all areas of life these days. But absolutely, with the vaccine mandates coming out, that's one thing you'll definitely want to be cognizant of, are these religious accommodation requests coming down the line. All righty, just moving on to, I'm going to flip a little bit. I'm going to talk about code of conduct first, which is the second main bullet. But what are what's your code of conduct? It sort of outlines the expectations of all employees about major infractions, and also may include details about progressive discipline. So that's not something, progressive discipline is not mandatory. You don't have to have that kind of policy. But if you do, it's something we sort of suggest having within the code of conduct or sort of close to the code of conduct, just to put employees on notice of sort of what your expectations are and the consequences, right, of not following those expectations. With progressive discipline, there's sort of multiple ways of handling it if you wish to adopt something like that. Oftentimes I'll see sort of, the first step being coaching, something sort of verbal. The second step could be a written kind of report that's made about whatever the conduct is. And then the third could also be, something as severe as suspension or termination. So just kind of outlining those steps and letting employees know sort of clearly what they can expect. Sometimes the 1, 2, 3, the levels of progressive discipline depend on the frequency, right? Other times it's a combination of frequency and severity, the severity of the action that was taken. So just making sure that that's really clear so that there's no sort of question about where the employee would lie within the progressive discipline policy. But again, it's not mandatory. It's just something that if you choose to do so is important to make clear. It's also a good way to, we've been talking about this all along, but having that code of conduct, right, is really important because say an employee alleges discrimination, but there's also evidence of him being insubordinate or not having good work performance, right? If those other things are in your code of conduct, you know, we don't tolerate insubordination, we don't, you know, we have a process in place to evaluate performance and we'll sort of monitor that. That's really good evidence of under this McDonnell-Douglas framework that we play with in these applies under these discrimination cases is that's just good evidence of the employee being on notice that the company doesn't tolerate that behavior, and they provide sort of the basis for that legitimate non-discriminatory reason for taking adverse action. So again, the code of conduct can be really important for that reason. And just touching base really quickly on lactation, you'll want to make sure, of course, that you're complying with the law, and that's something we tend to not see, but sometimes is omitted inadvertently, or language around lactation breaks. So you are required to provide reasonable break time for employees who are nursing or breastfeeding mothers to express milk. So you'll want to make sure you do include those language around that in your handbooks. Now moving on to a little bit of OSHA, I'd say sort of health and safety in the workplace. So you'll definitely want to make sure you have a health and safety workplace policy. And that's just to reassure employees that you are providing a safe and healthful workplace, and that it's compliant with OSHA Act requirements. If you are located in a state with a state plan state, that's about half the states in the country, you'll definitely want to make sure to refer to the state plan's requirements, which can differ from the federal ones. So a lot of times the state plan states adopt federal OSHA requirements sort of verbatim, but in others there are some differences which might apply to your workplace, and those are the ones that you'll want to make sure you're following if you have those workplaces in those states. You'll also want to make sure you have a substance abuse policy. OSHA considers substance abuse to be an avoidable workplace hazard, and strongly supports drug-free workplace programs. Another thing is workplace violence. That's something that's been on OSHA's radar, and is, OSHA is really sort of hammering that point. It's being cited under OSHA's general duty clause. OSHA doesn't have a standard for workplace violence, but a specific standard, but OSHA's general duty clause is sort of like this catch-all for recognized hazards. And this is one that is recognized, especially in certain workplaces. I think healthcare, I think, gas stations, just what you would think would be sort of higher risk for that possibility of workplace violence, but doesn't just, there's sort of no limit on the types of workplaces, but we do recommend having a workplace violence policy, and of course, strong language around that, right? A zero tolerance policy for workplace violence. And just in the interest of time, just going to move quickly through these. Employee benefits, you'll definitely want to provide details about your health insurance coverage and retirement plans to your employees. But what we do recommend is that don't make it too detailed. We sort of recommend referring to the benefit plan documents for specific details, and that's because the benefit plans do change constantly. So again, we don't want your benefit plans changing to be sort of a trigger for having to revise your employee handbooks. We think sort of leaving it at refer to the benefit plans and making sure that it is specific enough so that employees know exactly where to find those plans is sufficient and sort of makes more sense. Then touching on holidays, vacations, and sick days, employers typically designate paid holidays and can provide a certain number of vacation days or sick days. You should include language about whether vacation or sick days may be accrued, and determine if the employer will pay out any unused but accrued vacation or sick days at termination, and sort of the conditions under which an employee can receive that payment. You'll definitely want to have a family medical leave policy, FMLA policy. There's the federal level, but there's also state, we call them mini FMLAs. So you'll definitely want to refer to both of those and make sure that you are providing for the more stringent, right? Whichever is the more stringent, has the more stringent requirements. And also ensure that the policy accurately provides which category of employees are eligible for leave and the requirements to meet that eligibility. And so we do tend to, see longer FMLA policies, and we think that's appropriate, sort of providing all of those details. USERRA is the Uniform Services Employment and Reemployment Rights Act, and sort of provides military service leave. And so you'll definitely want to include that too for purposes of compliance with federal law. Next, just a few more points on NLRA compliance. This is about employee relations. We find that having that no solicitation, no distribution, no access policy in the employee handbook, that's something we always advise to include in there. You want to include your wage and hour policies, IT policies, making sure that your employees are aware that they don't have sort of any, reasonable right of, expectation of privacy or anything in your IT equipment. Making sure that they can't take anything that it belongs to you. Dress and grooming policies. One thing, myself living in DC, personal appearance is a protected category. So you'll want to be careful, make sure you do refer to those laws about protected categories in case your dress or grooming policies could run foul of those legal requirements. I've seen that in employee handbooks before, where there was definitely sort of possibly crossing the line. So we had to scale back and just revisit that policy. You also want to look at your separation policy, include information about confidentiality and conflicts of interest, and we'll mention it one more time, employee handbook acknowledgement. Always sort of including that as the last page of your handbook. And once the policies are in place, make sure to follow them, right? That's sort of the most important. We want to sort of walk the talk, right? Is once we've talked about it and written it down, make sure that we're actually practicing it. And I will talk really quickly, just one slide on training. So what's the big deal? The company may be strictly liable for your unlawful acts in the OSHA sphere. Managers, right, and supervisors, their knowledge is imputed on the company. So it's really important for your managers and supervisors to know about your policies and to enforce them. Also, you may be strictly liable, personally liable in certain situations. So under the DC Human Rights Act, it permits employees to sue an individual manager, and they can also bring tort claims. So you'll definitely want to make sure that, once you have your policies in place, that your supervisors and managers are fully aware of them and know how to enforce and implement them. And I'll turn it back over to Aaron to continue the section.
Thanks, Bita. And yeah, just to put an exclamation point on the personal liability piece, same thing or similar concept here in Illinois, where I'm based. Managers, supervisors can be personally liable for sexual harassment. So there's probably nothing more effective than getting managers to sit up and pay attention during training when you tell them that their own personal bank accounts could be impacted by allegations of sexual harassment. And I even worked on a case where I was representing a small law firm in where a partner had been accused of sexual harassment. We were initially retained and to represent both the firm and the partner. And after I determined through my investigation that this individual had clearly violated the firm's policies, we withdrew. We had a joint representation letter in place, advised him of a potential conflict, ended up withdrawing from representing him. He had to hire his own counsel. And in that case, ended up having to pay the settlement that he entered into with the employee out of his own pocket, and it was a very significant settlement amount. I think he may have had to sell a second like lake home or something that he owned. So that's the sort of thing that gets people to pay attention, which is not always easy in today's day and age when you're doing training, whether it's employees or managers. When I set out to deliver training to managers, and that's primarily who I provide training to when it's not all that common, although not unheard of, to train hourly employees. But I think the objectives are very different. Obviously, when you're training non-managerial employees, whether they be hourly or salaried, the primary focus, from my perspective, is more educational. What do our policies require? What's expected of you as an employee? What are the resources available? What should you do if this happens? What should you do if that happens? If you're a victim of sexual harassment, these are the avenues. This is what an investigation looks like. Things like that. You can talk about some of the things similar. There are similar things that obviously apply to all individuals that work for an organization, whether they're managers or supervisors. But when I am delivering training to managers, I tend to focus on some things that are a little bit different and specific to them. One is that they are the employees obviously are looking to them to set the example. And in that vein, I like to have senior management, if it's not the GM, the plant manager, the president, the owner, whomever it is that kind of carries enough weight, if they can be present for the training, if they can introduce the training. It's a lot more impactful if the president of the company, if he or she is present and says a few words about how important this policy is, the value of compliance, as opposed to showing someone a video in a conference room or having someone who's a low-level functionary that just kind of kicks off the training and leaves the room. It's two very different scenarios. But managers need to understand that whatever the policy is, whether it's attendance, whether it's harassment, whether it's safety, that they are setting the tone. They're setting the example. Employees are going to be looking to them. It's going to be hard to hold employees accountable if the managers aren't complying as well. Make sure that the managers understand and are what I like for them to be able to do at the end of the training is to spot issues, that they have that heightened sensitivity and awareness as far as what is harassment, or what, more importantly, probably what might be harassment. I like to tell managers, you don't necessarily need to know the legal definition. You certainly don't need to know what the outcome is going to be if someone comes forward, but you need to be able to recognize what might be harassment and what to do if you see something that might be harassment, who to notify, how quickly to react, things like that. They should, managers also need to understand the protocols, the avenues to get in touch with human resources, who the points of contact are, what sort of issues that they should go to with HR. I think many managers have sort of a problem-solving mindset, whether for good or for bad. They want to just solve it, and either because they think it makes them look good, or that's their personality. And I think if you make clear to them that there are certain issues, certainly, that are not, it's not either expected or wanted that they're solving those problems. And in fact, I always tell a number of stories in training sessions about well-meaning managers who tried to solve a problem and made things a lot worse. And then just kind of the role that they play as far as coaching and counseling the employees, reminding them of the rules, reminding them of the expectations, and the role that managers play in that regard. I think those are all very important and essential elements of a effective training program or training regimen for your managers. Then turning to the next slide, this is like I said at the outset, something I didn't cover 20 plus years ago when I talked to or present on training, because it really wasn't a thing. But now, with the advent or the availability and prevalence of electronic training options, whether it's at a workstation in the office, whether it's something that people can do on a laptop at home, not if they're non-exempt, but many different avenues to complete training. Pros and cons, I think, obviously from the perspective of turnover, where it might be very difficult to have fully live training at all times. You have, whether it's recorded training, whether it's kind of on demand, things like that. It enables you to reach people more directly, or more immediately, if there isn't, as opposed to finding time to schedule a training session. Some employers might do one large mass hiring and onboard a bunch of people together in which they can teach a class. Others, it's going to be filling one position at a time, which could make obviously training a little bit more difficult. One of the things to consider, though, if you are relying on electronic training, is to consider including some interactive components in the program or in the materials that will help keep your employees engaged. Obviously, I think we've probably all done it. When you're taking or completing a training course online, it's easier for people to become distracted or disengaged. If you have interactive components, whether it's a survey, whether it's scenarios or videos, questions to which the employees must respond, or other exercises, those can help ensure that their attention is more focused, even though they're going to be spending a significant amount of time staring at their monitor or television screen. You also want to make sure that you have some sort of check in place to verify that employees are actually paying attention to and engaging in the training. Again, that could be questions that they answer periodically throughout the session, providing a quiz either at the end of the section or at the end of the program itself. I know when I do the occasional online CLE, continuing legal education, some of those programs have a little dialog box that pops up every 6 minutes or so and says, are you paying attention, or are you still there, or click this to continue, something like that. Keep in mind also, particularly I think with harassment and EEO type training, some jurisdictions have laws or requirements that employees must be allowed an opportunity to ask questions related to the training. We've seen that more recently in a number of areas. So obviously, if you have a live trainer providing the training, that person can field questions throughout the training and at the end. If however it's pre-recorded training, then you should have somebody, you should make sure you provide an opportunity that you can either ask questions during the training or after. Perhaps an HR person comes in at the end to answer any questions, or you have a separate question and answer session. I can tell you that for almost every single time I've ever presented harassment or EEO training to managers, I think I've gotten a question, or at least one, if not more questions at the end, that dealt with a specific and often recent scenario that came up where something had not necessarily either had not been addressed, not been escalated. Usually it quite often deals with the part where I talk about not promising to keep something confidential if the employee asked to keep it confidential, and almost inevitably someone raises their hand and said, "Oh, I just did that. Is that a problem?" So just the mere value of using training, not that that's why you do the training, but it can surface issues that, whether it's training to your HR team or your managers, that people might have been trying to solve on their own. Now they realize that maybe they should have done something else, or should be taking a different approach. And then last but not least, make sure that there is some sort of tracking system that captures when each employee has completed the training, just like the unfortunate rule of thumb that I seem to see all too often with the one person filing the lawsuit didn't sign the handbook acknowledgement. Same thing with respect to training. You'd hate it if the one manager who didn't complete his or her sexual harassment training is the one that was accused of harassment. Even take look at this. If you're using good old-fashioned pen and paper sign-in sheets, make sure that everybody who attended signed their name. Look at what they signed next to their name. Believe it or not, I once had a case where a manager had signed in for sexual harassment training as Larry Flint, the publisher of Hustler magazine. I guess this manager thought that was funny. Not so funny when you're trying to defend a sexual harassment case. So, even kind of drill down to that level of detail. So I think then moving on to our last section, and internal compliance audits. This kind of gets back to what both Beat and I have talked about, which is walking the talk, so to speak, and making sure that you are doing what you say you're doing, and complying with the policies and procedures that are set forth in your own handbooks. Before I jump into that, just a couple of real quick notes. I did want to comment, as Bita mentioned, USERRA, the Uniform Service Employment Rights and Reemployment Act. I actually tried a USERRA case a number of years ago to a jury in Tennessee. It is a very much, I would say, overlooked law, particularly with the number of employees perhaps being drawn down and returning to the workforce after serving in Iraq or in Afghanistan. There are, in addition to leave requirements, there are, as the name of the law indicates, the number of requirements with respect to restoration of job rights, the handling of time off needed for regular training. Basically, the way I kind of characterize USERRA is it is probably the most, and understandably so, pro-employee law of all the employment laws out there. So just be very mindful of that if you're dealing with USERRA questions. There's a lot of guidance out there, organizations, quasi-government organizations like the ESGR, Employer Support for the Guard and Reserve, and service members are very well educated and informed of their rights. The organizations and the armed forces make sure of that. So when they generally know what is required of, or what their employers are required to do. I don't think the handbook policy on USERRA needs to cover most or any of those eventualities. It can be a short statement as to compliance with the law on a few essential elements, but it is important that you make sure you're familiar with all the aspects of USERRA. And also another quick note, when Bita talked about the FMLA policy, obviously if you have fewer than 50 employees, at least under federal law, you would not be required to have an FMLA policy, but nonetheless, many employers that are at or below that threshold will have some kind of general leave policy. And as Bita said, you may well be covered by kind of some of the mini FMLA policy or laws in some states that may set a lower threshold. So with that, as far as training, or I'm sorry, as far as internal compliance audits, there are generally 4 types of audits. We're going to focus on the first, which are compliance audits, which are really looking at whether your organization is complying with the applicable federal, state, and local laws that govern you and where you're located. There are audits that are focused on best practices, where you're benchmarking your organization against the best of the best. So example, in safety, if you're looking to, your auditors might look at, what company has the best safety practices for a certain issue, a certain substance or chemical. It could be just a general safety program. OSHA always likes to talk about Alcoa as kind of a company to benchmark against for how they handle near-miss accident or near-miss incidents. There are strategic audits where you're really looking and trying to evaluate, do the systems and processes that you have at your organization, are they aligned such that with your strategic plan? In other words, do those systems, programs, policies enable your people, your personnel to carry out the goal or goal set in your strategic plan? And if not, how do you change them so they do? And then would be more of a function specific audit where you might have an issue or a concern about a certain area or certain aspect of your operation and decide you're going to look specifically at something like records retention, or retaining the right records. We're having performance problems. What sort of do we need to change, or do we need to adopt or change our performance management program? Things like that. So then, what are some of the advantages and disadvantages of performing audits? Obviously, I think as a baseline consideration, doing voluntary audits are essential. I think doing them with some sort of regularity to help you determine areas where you may be falling short, where you may not necessarily be complying with certain laws and regulations. If you do that and you close out those recommendations, then you're able to use the audit kind of in quote an offensive manner, meaning that you can show that your organization is proactive, that you take compliance seriously, that you devote time and resources to compliance, and that's an effective way to counter claims that might be made by plaintiff's counsel, by a regulator, that you were negligent or that you had even acted willfully. Someone who is on the safety side, who's conducting regular safety audits, whether with their own safety team or with using a third-party safety consultant, it's a lot harder to say, oh, this employer is willfully violating safety regulations if you're taking those sorts of steps. Obviously, the flip side, and I think the worst thing that can happen is kind of like, I think you'll be getting, probably drawing a theme here, is just having a policy or a handbook in place if it's not well done, if it's not customized, and certainly if it's not being lived, can almost be worse, as Beat said, not having one at all. And so if you're doing audits just because someone says, oh, it's a good idea to do audits, let's do an audit, but there's really nothing kind of built around that, that can be a problem. I had a client not that long ago that had this process where they get employee feedback on a regular basis, but there was no mechanism in place to analyze the feedback that was received, to track it, to assign responsibility for addressing the things that were identified. And so what happens? Well, the government gets its hands on that, and now they have a roadmap for their investigation, if it's EEOC or their inspection, if it's OSHA, that really can kind of show them like, well, you already knew about this issue, and now again you have the basis for an intentional or knowing violation of the law, as opposed to one that was more negligent. And obviously, depending on the stakes, then you're also talking about anything that is a knowing violation. It has greater potential for reputational harm. It's the sort of thing that can result in press releases and nasty language that talks about the company knew what was happening, knew what its obligations were, knew about this manager who was doing terrible things, knew about this unsafe condition, and still failed to act. So another question, or one of the questions to ask then, if you make the decision, okay, we're going to go ahead, we're going to do an internal audit, or we're going to conduct an audit of ourselves, who's going to do it? Do you want to use people who are internal, part of your organization? Are you going to use an outside HR consultant? or perhaps legal counsel who does the assessment or the audit with or without a consultant. If you're going to look internal first, obviously you need to make sure that you have people on your team who have the ability and expertise that they can spot the issues. Got to make sure they have time to do the work, which is far easier than done normally, but particularly right now. We were just having a conversation about some initiatives that we wanted to undertake, and I said, well, that might be something that we hold off on until COVID calms down. Maybe we start laying the groundwork or the framework for that, but we know we can't really necessarily execute on that right now due to everything that's going on. Certainly, as a vaccine emergency rule is potentially heading our way. This is something we put off until we have the ability to focus on it. Obviously, if it's a mission critical thing, that's an entirely different consideration. Hopefully you can assess whether you have people who are able to and willing to make tough calls, particularly now. It's not a tough call whether to adopt an EEO policy, but it could be a tough call as far as determining we're not living up to our policies. We have to make some hard changes. And then does that person or the people involved in that process have the clout that they can drive change? Change is never easy, but when if change involves ending people's employment, changing their responsibilities, bringing in new people, you may need some real clout to back those up. If the answer, your concerns about any or all of those aspects, then you may want to look outside your organization, perhaps to retain an HR consultant, presumably with one on subject matter expertise in the area or areas that you're looking at. If you're doing a pay equity audit, you want somebody obviously who has extensive experience with pay fairness issues. If it's looking at harassment, you want someone who's done a lot of work in that area. The one thing to consider, whether it's an internal or outside HR consultant, is generally everything that takes place in that audit is going to be discoverable later down the road. So if you think everything's in pretty good shape, you might just need a little fine tuning. Probably fine to go ahead and do it with either of those options. If you have some real serious concerns, you think there are some very significant gaps, then it may well make sense to have legal counsel oversee the audit, have counsel retain the consultant. The consultant reports to the lawyer, and then the counsel shares the findings and recommendations internally with key folks in your organization, develops a plan going forward. It's not certainly an absolute ironclad guarantee that none of that is discoverable, but it certainly sets it up with a much better argument that it is. So then just quickly, a couple of benefits of conducting privileged audits is they're more likely that you can have a robust and meaningful report that won't come back to haunt you, because it's, again, likely to retain that privilege that covers those aspects. And perhaps you're more likely to have kind of valuable and robust discussions, back and forth analyses, reviews that people feel that they can have without concerns about this, again, coming back to haunt the organization. So moving on to the next slide, some other considerations to think about during this process. I think consistent with what I talked about earlier. What sort of resources are available to do the audit? Are your decision makers folks that are going to either be involved in, or the ones that are going to be tasked with making the decisions or implementing the changes? Are they, not trying to overuse the term align, but I think it does fit here. Is everyone aligned with respect to what the priorities are, why we're doing this, when we're doing it, how quickly we're going to be making these changes? Is there agreement about what your perceived or acknowledged weaknesses are, what your problem areas are? It's going to be a lot harder to get buy-in if a couple of people think that something's a real problem, but other people are very defensive of that or believe it's totally fine. It can help if you look at what sort of issues your peers have. If you can point to examples of a similar company or an employer in the same area has struggled with these same issues, that can help in regard to, I think, getting folks aligned in those respects. Then moving to the next slide. Just as Beta talked about the kind of key must-haves in your handbook, I think when it comes to the types of topics to look at from compliance audits, I'd say the things that are probably most frequently looked at by the clients that I work with, or where they reach out to us, either for assistance or advice. Many of the topics include wage and hour, various aspects of your wage and hour program. So do you have, are your time records and timekeeping methods appropriate? Here in Illinois, we've got this Biometric Privacy Act that's been tripping up a lot of employers who are then subject to costly class action lawsuits. So not only timekeeping, but just the method in which you obtain records of time, taking a look at the policies and procedures that go around that. Obviously, perhaps the most common is your misclassification. Are your exempt employees actually exempt? Do you have too many people? You have more people exempt than should be. What are the ways that you can go about fixing that, or certainly assessing the problem, and then it's deciding on how to fix it is to conduct an audit of that. Relatedly, if you're perhaps overusing independent contractors, evaluating the type of work that's being done, the status of those individuals to determine if some or most of them should actually be employees, or ways that you can make changes to the way you're dealing with contractors so it increases the likelihood that they are in fact contractors, not employees. Generally, evaluating your personnel, the files that you're maintaining, are the right things in there? Are you sure that none of the wrong things are in there? Is medical information segregated in separate confidential files? Certainly something to look at when it comes to records of vaccines as well. Immigration compliance audits are another favorite, and I think one area that is particularly beneficial to be proactive in. I know there are a lot of folks that are very expert at doing those types of audits, and they can be done if they are done in the right way at the right time, and you end up then being audited by INS. It can really cut back on and help you avoid penalties and fines associated with incorrect record keeping there. I mentioned earlier about the client that I worked with on ADA policies with respect to accommodations. As I again mentioned before, with the explosion in religious accommodation requests, I think this is an area that would be wise to audit and evaluate. I did see a question that just popped up a second ago about whether having in-house counsel manage an internal audit is sufficient to cloak it in the attorney-client privilege. I think generally the answer tends to be no. It's possible. It's certainly more likely than having no legal oversight. It's certainly doesn't preclude the application of the privilege, but given the fact that many in-house or corporate attorneys are kind of wearing multiple hats, sometimes they're providing legal advice, other times it's kind of more operational advice, that you have to be very careful about the roles and the manner in which inside counsel is supervising that effort. So not saying it can't be done, but it's a little bit riskier. And I think then, as far as just moving to the next, which is I believe our last slide, as you're setting out to conduct an audit, generally the process would be to first determine the scope. What are you going to be looking at, and what type of audit that you're going to be doing? Again, if it's who's going to be doing the audit, what the timeline are, all the kind of everything that goes into that process. Figure that out. Then develop an outline or questionnaire, list of documents, list of information that you need. Set out collecting that data, reviewing those documents, gathering that information, evaluate it, then benchmark your findings against what the expectations or goals or objectives are. Develop and provide the feedback. create an action plan. And that again, probably is the most important part, right? That's once you've determined where the gaps are, where the shortcomings are, identify an action plan to address those, who's going to be responsible for them, what's the time frame that they're going to be addressed, track that, make sure it's done. As I mentioned, that client that got in a little bit of trouble not that long ago, that was receiving feedback and then not really reviewing it, not acting on it. Again, worst of both worlds, because the government investigator sees it and says, oh, you have knowledge of this issue. Even though you didn't read it, the document's in your possession, so you have knowledge of it. And so same thing here. You have an audit report done, there are recommendations. Don't just assign them out, track them, follow up with the person or persons who are responsible for implementing them, and make sure that they're closed out. And then have something in place to ensure continuous improvement. So it's not just you fix it once and forget about it, that you come back and look at that issue, look at those changes, those updates on a regular basis. And that is it. We thank you for sticking around. I think we always set out to try to get these programs done in about an hour 10. But I think we as lawyers, it's always hard to talk or to keep it as short as we'd like, because we have so much information that we want to download to you all. So we thank you for joining us today. If we didn't get a chance to respond to your questions, we will go through the chat and reach out to you if we're able to. Just a quick reminder, we encourage you to take a look at our blogs, both the Employer Defense Report as well as the OSHA Defense Report. We have, it's hard to believe, or hard as it may be to believe, but it is getting towards the end of September. We still have a number of webinars left in October, November, and December. Take a look also if you have questions about COVID-19, which I'm sure you do. Our task force continues to put out good content on our website. We have a number of FAQs and other sources of information. So hope you'll take a look at that. And then again, here is our the remaining webinars. So next month we'll be doing an NLRB update with our most excellent traditional labor lawyers here, and hope you'll join us for that. Thank you.